13th, 2022. I will motion to open the meeting. Can I have a second?
Second that.
And all in favor?
Aye.
Aye.
Aye. So in attendance at the board meeting in person is Board Member Susan Stevenson, Board Member Luke Ferrin, myself, Mark Greenwald, and via Zoom, we have Board Member Julia McCormick. Our legal counsel is here, Jeffrey Blinkoff, as well as our environmental consultant, Chick Voorhees, and our village planner, Alex Wallach. So we will move to the first decision, which is ready for a vote, which is case number 3148, Heart of the Hamptons. I will motion to accept the written decision. Can I have a second?
Second.
And all in favor of accepting the written decision as written, approving the variance requested by Heart of the Hamptons in case number 3148, please vote. Susan?
Aye.
Luke?
Aye.
And Julia?
Aye.
And I will vote aye, so that's unanimous, approving the decision in case number 3148, Heart of the Hamptons. I did skip case number 3132, Lee Cruder, 370 Great Plains Lane, the case,
Road.
road, it
There
says.
is no lane.
Road.
I will change
Great
it.
Plains.
The application and the hearing is closed, but we are not yet ready with our decision. So we can move to our first pending case. Well, no, first I skipped over. We have to, in case number,
We're all the way to twice, then.
well, we have an adjournment to accept.
Oh.
So I'll motion to accept the applicant's request for an adjournment in case number 3144, Stephen Hickey, 1377 Meadow Lane. Could I have a second?
Second that.
And all in favor of accepting the applicant's request for an adjournment to December 13th in case number 3144, 1377 Meadow Lane. How do you vote, Susan?
Aye.
Luke?
Aye.
And Julia, accepting the adjournment? Aye.
Aye.
And I'll vote aye, so that's unanimous to accept the request for an adjournment in case number 3144. So we can move to our first public hearing this evening in case number 3147, Andrew Fleiss, 64 Down East Lane. Before we hear from the applicant, can we hear from our environmental consultant, Chick, what you have found with respect to the property? And Alex, you can weigh in, and then we can hear responses from the applicant.
Yes, of course. Just trying to get connection. Close.
Come. There you go.
Charles, are you able to hear, Chick? Do we need to move the microphone?
I think I'll
He's
go.
gonna go to the podium.
Okay, perfect.
A little scary. There's a camera right there. Huge. Okay, so at the last meeting, we had talked quite a bit about this, and there were a couple of concerns noted. One of the primary ones was that there was a prior
We're looking at your at the
agenda. You are, okay.
So you know that.
Yep, thank you. There was a prior ZBA decision in 2000, and so we were looking to ensure conformity with that based on the recently adopted law that Jeffrey Blinkoff quoted to the board at the last meeting. There was also some discussion just regarding the need for a buffer, the configuration and orientation of the dock, quite a bit about the language, whether it's a dinghy dock or a kayak and canoe dock, and things of that like. So since the last meeting, I did go to the site and inspect the property. And I want to see if I can get back to my share and show some photographs that were taken at the site. That seems to be zooming in, so that's good. Okay, so this is, I'll just go through these in order. This is the dock across the street at 405 Captain's Neck that the applicant, who's here tonight, Jim Walker, had indicated that he had permitted this a couple of years ago. It was in the location of a prior dock that was resting in the wetlands, and this is an elevated structure with through-flow decking that goes beyond the edge of the marsh and into the canal. This is looking, I guess it's east for some purpose. It's to the left, down along the property itself. And this shows a really nice Spartina alterniflora stand. You can see the groundsel bush in bloom. You can see a little bit of Phragmites to the left. And this is the shore of the 64 Down East Lane property. I believe, and maybe I'll just ask Jim, the stake, is that the location of the terminus of the proposed dinghy dock, kayak dock?
It is the western end.
The western end, good. I thought this was interesting because it really does show a nice healthy marsh. It's different than the opposite side, which is dominated in Phragmites. And I had expressed some concerns about just ensuring that that marsh is able to grow and continue to flourish, because it really is quite healthy. And there aren't that many water bodies in the village that aren't completely choked out with Phragmites. So I feel that that's pretty significant. Okay, so as we talked about the area leading up to the vegetation and the marsh itself, this is a gate that goes through the roughly a little bit landward of the limit of wetlands and provides access to the water body. There are basically stepping stones placed over the marsh in that area that go down to the waterfront. And apparently that's how access is provided now. This shows a fence, and there was a fence referenced in the 2000 decision, and I know that Alex located that and sent it around. I am not sure that the fence is in the exact same location because it just looks a little bit different. So we'll have some discussion and recommendations with respect to this. You can see the, I think it's a Japanese red maple. And this is looking along the property toward the one corner that I will lead towards in a couple of additional photographs. This is roughly from the center of the property, looking toward the corner. And this is, again, from the center, but more toward the corner of the property that shows a swing set that has been placed. You'll also notice that there is a lawn area that has been established right up to the fence. And those are the current conditions of the site. So I had prepared a pretty detailed email report to the board members to kind of interpret what this was showing to me. And I may be able to get to that as well. Well, I'll summarize it. Basically, the findings, in my opinion, are pretty apparent that the property is not in conformance with the ZBA's 2000 decision. I would go so far as to say that there could be, subject to building department review, a violation on the property by the establishment of stepping stones within the wetlands without a permit, the modification of yard areas within 125 feet of the wetlands without a permit, and the installation of a swing set without a permit. and also potentially some removal of vegetation. Alex had provided some aerial photographs that were also quite helpful that showed the modifications over time. And so those were the findings. And Jeffrey can speak again to the current law, but it appears to me as though we're really not able to review this because reviewing a proposed dock structure is not in the spirit of the law of resolving a violation. And you'll note the conversations that we had at our last meeting on another application which did meet that particular objective of the law. In this case, the dock is a separate application, and it is not really furthering or advancing the resolution of a violation. So, again, we may want to ask counsel, but that's the way I'm seeing it at this point, that conformance is needed, that there is I'll call it a potential violation, but you can see for yourself the findings from the site inspection and photography. And so those are items that we can discuss as we move forward. The other item that I was asked to look at was the drainage easement, which is noted on the survey of the property and traverses basically the wetlands areas. And I did reach out to Village DPW. Gary Gillespie is still working part-time, and Steve Phillips is available. They had gone and done an inspection of a drainage pool that's located on, I believe it might have been down, it is down East Lane. And they found that there is, oh good, I got the share. So this is the drainage review. There's a drainage pool, if you can see my cursor, right here. And it connects to about a 20-foot pipe, which would only take it, a little bit into to the south. And basically, this is just all surface open discharge on an as-needed basis to ensure that the roads don't flood. I did put in my email to the board that the village is under an MS4 program. There's a 5-year report and annual reports that are updated. Drainage improvements are being made all the time. You know the intent of the village board for water quality protection and implementation of stormwater measures and water quality benefits all over the village. That still is occurring. But for this purpose, there is a release of stormwater from down East Lane that traverses basically over the land after this limited length pipe and traverses through this channel area to the more open water area. And what I got back from Village DPW, that as long as the proposed structure does not obstruct that flow of water, they did not have any concerns. They didn't feel there were any limitations or need for them to comment further on it. And I put that in an email to the board. So those were the two items that I was asked to look into and to present this evening, and we can certainly discuss it from there. I know the applicant is here, they have submitted some materials, and I'm ready to further discuss as needed.
What might be helpful, Alex, do you have aerials that represent some of what Chick was referring to as far as the buffer zone?
That overlay image that you prepared.
Yeah, I can share the overlay if that's helpful, or there's some aerials that I had shared with the board as well.
Yeah.
Yeah,
Mark, you're talking
can we
about.
share that?
Yeah.
And then, Chick, you can comment on it, but
Yes, I
It
have
was
those as
helpful.
well, and Alex did circulate those.
Charles, I think I'm just going to ask you to promote me to panelist so I can share my screen. Thank you. So I can share some of the materials that I had previously shared with the board, and I'm happy to go back to anything. This is just a visual comparison from the 2000, what's labeled as a wetland mitigation plan as part of the previous decision. And this just has the existing survey that was submitted as part of this application superimposed on top of it, so the board could get a better sense of how those relate spatially. Highlighted in green is the area that was proposed as a buffer area according to that plan. And highlighted in red is the existing 6-foot wire fence that Chick shown in some of his photos. And this, I think, is just showing the same thing, but with an aerial image instead of the current survey. So you can get a sense of where that fence is in relation to I believe this is the tree that Chick had highlighted on his inspection, as well as the swing sets that's there. I have some aerials of the property if you'd like me to go over that as well.
Please.
Yeah.
Sure, okay, let me just go back to that. These are from Google Earth and some other sources. So this is the property in April 2004. This is April 2021. You can see where there may have been some, looks like some other plantings there at the time. This one is dated July 2022. It's one of the more recent images that we have.
So
This is, sorry, go ahead.
Does that show that it was mowed more than before?
Well, it looked like this is showing June 2021, that there was some change over time. And there were some plantings that were there. This is March 2021.
Oh, that's spectacularly ugly. Sorry.
And this is October 2021.
And then do you have the 2022, or did we see that?
Yeah, I'll go back to that.
Well,
This is July of 2022.
that's the one that seems so manicured, I would say. Mowed. Is it more? No. Did they mow further down from the tree?
Well, it looks like that line that's shown here, I believe,
yeah,
corresponds
yeah.
to the fence. So it looks like
Oh, it's the fence.
yeah, I
Okay.
believe so. And it looks like
So it's the same. No, it's,
There's a lot more out.
yep. Is that a winter?
this is
That's
was March.
March, lovely.
So it's
What about the fence? Is that's, I know that it was mentioned in 2000 or whatever, but is that okay? Are you allowed to have fences?
There was a fence
I
there
know, I heard that.
in 2000, and it was not asked to be removed at that time.
Uh-huh.
So, again, I mean, some of my recommendations had to do with trying to figure out the boundaries, because not everything matches up exactly. You know, the wetland line may have been a little different in 2000. You can see that the fence line, the best that we can tell from that landscape plan rendering from the original permit, seems to be in a little bit different orientation. And so I had, it would be my suggestion that some of these things be surveyed and staked in the field so we can get a sense of where the original landward limit of the buffer was. And that way we can determine exactly what modifications took place. Certainly the buffer should be restored as per the plan. And things of that nature. I had a couple of other points that were in my email of November 6th as well.
Thank you, Chick. Does the applicant want to address these concerns?
Good evening, Carl Benacasa for the applicant, 860 Montauk Highway, South Watermill, New York, 11976. Could you put up, I think there was one from October of 21, I think you mentioned.
yeah.
So I could see that. I hadn't seen that before. That seems consistent with the 22 aerials, correct? That's the 22, right?
Mhm.
Yeah, so if we go back to 21, the reason I'm asking is my client took title this year, and the CO was issued this year. So the building department issued a certificate of occupancy in 2022. And if we go to the October of 21, you'll see that the CO was issued for the property in the same condition that it is today. I bring that up for relevance related to Local Law 20 of 2022, discuss the fact that the building department has reviewed this property in its current state and determined that no violation exists. Therefore, as of this moment, that section is not applicable as far as your consideration. I think more importantly, and more to the point, Jim's going to speak in a moment about a revised plan that we are proposing, which includes various natural plantings and a buffer zone, cognizant of the existing conditions and the conditions as will exist post-doc. Remember that buffer that was imposed in 2000, from my understanding, is not cognizant of our client's riparian rights. Again, he cannot be precluded from access to the water, even via a buffer. Those rights dominate. So I think we should consider this application on its merits, and perhaps this board could use its discretion to revise the 2000 planting plan in a way that is cognizant of the existing conditions, the existing development, the proposed development, and the change in environs of Hetty Creek. And with that, I'd ask Jim to speak to discuss our revised proposal. And then procedurally, council perhaps I can discuss options for amendment.
Jim Walker from InterScience. Alex sent over the Tim Rumpf plan, and then I went to go visit the landscape architect because their office is next to ours. And then I had George Flanagan, who works for Tim Rumpf, call his dad, and we got a copy of the actual resolution. So we have all those items, and what we did since that time is we've moved things around with the dock to the extent that the kayak platform is out of the wetlands and landward of the wetlands. And we need a 4-foot wide path down to the dock. But short of that, the drawing that Chick was nice enough to put up is an attempt to recover wetlands buffer in a manner that allows the pathway down to the water, but also provides plantings in conformance with the 2002 planting plan. Now, relative to the dock, we do not have the stakes yet from the surveyor, so we have to have some consideration from the board while we finish with Pat Secafico's office to get that done. But it will be done soon. And then we need to know from Chick what was in the email and what else that we would need to have surveyed. But the idea is that we're coming back to the board with a friendly planting plan to start the process of fixing the problems on the property. Those planting plans that I prepared provide plant materials that will succeed and will provide habitat and will take the nutrients out of the lawn runoff and make it function as a proper buffer. It's not intended to be perfect. It's intended to be a working document that we will hear from Mr. Voorhees and hear from the board and finish up. Property owner is horrified. Didn't know anything about a 2002 variance. It would be a better situation if wetlands buffers were part of a notice deed or at least a declaration of covenants filed with the county so that future property owners don't run into this situation. However, we're trying to make the best of it, and I think that's mostly what I want to say to the board.
Jeffrey, where should we leave it? Because I guess the question is whether the new recently passed trustee regulation precludes us from processing the application. It's, to my mind, you know, a question of language, really. Does a violation exist even if a certificate of occupancy was issued? You can advise us, you know, on that. What I have, in summary, is there was a prior zoning board decision which required the implementation of a wetlands buffer.
Yes.
And that wetlands buffer was either never implemented or is certainly not there now, even though it was a condition to prior relief granted.
Seems to be at least partially implemented.
Right.
Based on the air photos that we looked at
Mhm.
and taken out, and then the property was sold. So somebody
Right.
changed the conditions there about
Mhm.
the time the property was put on the market, which is unfair, but that's the way the ball bounces, and we're here to correct the problem.
So, I mean, that's what we'll have to figure out.
So I heard what counsel said, but I respectfully disagree on some of the points. I do think the current local law would apply, and I'll explain why. First of all, even assuming, and I'm not assuming this, but even assuming the building department made a mistake in issuing a CO, a village is never halted from enforcing its own code. So if a violation was observed as recently as yesterday, the village has the power to enforce its code. The CO doesn't speak to the issuance of the prior zoning decision, but the local law does. And if there's the existence of a violation on the property, what the Board of Trustees has determined is that no board or department can process any application. That doesn't mean that the applicant can't amend, seek relief that deals with the particular open violations, which were not noticed for this particular hearing or brought before the board, but that's something that they could do. I've also looked at the code because there are certain circumstances in which that local law doesn't apply.
Mhm.
And one of those, for example, would be if the application before the Board of Zoning, as a result of its outcome, would cure the existing violation. If the sole purpose of the application before the board was to cure that violation, then the board could proceed, because otherwise you'd end up in this sort of catch-22 where nobody could go forward because there's a violation. But that, from the description of Mr. Voorhees, from the overlay that's been shown, that doesn't seem to be the case here. The other point I wanted to make, and I certainly understand council's discussion about riparian rights, it seems then that what the applicant is in part arguing is that the 2002 decision was incorrect, and they're essentially seeking to reopen a prior decision of this board. This board didn't issue that decision. This was a previously rendered decision that directed the type of buffer that's to be put in place. I'm not saying that at some point this board shouldn't consider the application, but under the current local law, as I understand it, this board would not be able to proceed to completion. That doesn't mean that the board can't get there. I have also communicated with the building inspector. We're waiting for a further update from the building department, but all that's been shared tonight from Mr. Voorhees, from the understanding that I have received from the building department, is that there is at least, there are potentially several violations on the property. It doesn't mean that this was done with malice. Please don't think that what I'm saying is that the applicant was trying to hide anything. That's not the point.
Right.
The point is, if the violations are there, the purpose of this local law, the intent of it is to get everything cleared. And the problem under the local law with proceeding in terms of saying, well, can a board proceed subject to? The concern there, and this is that there were conditions before. And then here we are 22 years later. So I think this local law was set up in a way to hopefully avoid that particular problem. So that would be my position on it. And counsel had said he wanted to discuss with me. I have no problem speaking with counsel at
Yeah,
other times,
perhaps
but that's my opinion based on the review of the record that we have.
Would council, if we were to include this relief as part of this application, an amendment to that planting plan, with an eye towards conformity, would it be your position that it'd have to be renoticed? Or I know that the board is empowered to consider anything it determines reasonable and complementary of an application. And typically.
May I respond?
Sure,
I don't-
of course.
I do think it would need to be renoticed, not to cause more difficulty for anybody, but the application that's being heard now, and that anybody who read any of the notices now would not have seen the other forms of relief. So look at it this way. Just let me finish the
Sure.
thought. My position is that whether or not there's a covenant, the owner is bound by what the prior determinations were. Your argument was, well, maybe, it's kind of unfair. I think that's what your client had said, because we might not have seen it. Everybody should be able to see everything. Research I would submit would have shown the decisions. But to the same extent, somebody who wants to know what's going on with this board should have full and fair knowledge of what the board is going to consider. So I do think it would need to be renoticed, because if it's not, this board could later be open to the criticism that the public didn't know what was being considered. I think that there are different forms of relief being sought, so I do think they should be noticed.
Oftentimes the notice, and I admit I haven't read the notice that was in the paper for this application, but does it say any further relief deemed necessary and proper by the board in the notice?
I don't know, but I do know that my concern would be that there's not a denial letter that's been prepared with respect to the other issues on the property. I think there would need to be a denial letter, would need to be noticed and then brought properly before the board. Otherwise, this board's not going to have full jurisdiction over those matters. So that's why I think there would need to be the new notice.
Understood.
That's the way I'd be advising the board.
So I will consider that with the client. Maybe that is the best option, to renotice with relief for a planting plan. If that's your council's recommendation and the feelings of the board.
Yeah, we are just now kind of considering the new regulation.
Sure.
One way in which it is to be interpreted is we cannot hear the application until this buffer is, implemented. Once the buffer is implemented and you're in compliance with the, prior zoning board decision, then you notice for, the dock or anything else. So that's what we need to discuss among ourselves. It's not just this application, it's how we're going to handle every application. There's another application, different, but the applicant basically has been adjourning because they're correcting the prior quote-unquote violation, or the fact that they have also discovered that the property does not conform with a wetlands buffer. So this is just a matter of how we're going to treat consistently every application.
So the local law, two important terms in the local are, one, the building department has actually determined there's a violation, and I don't think we're there yet. I'm not saying we won't be there. But as far as I know, the only decision from the actual determinations from the building department is that this was to code, and that was the issuance of the last CO. And second, as council noted, if we are seeking relief with respect to that violation, if there be a violation, you are able to consider that relief.
Mm-hmm.
So perhaps we have to get a variance for that planting plan first, and then at that point we can pursue the dock. It seems to me that's a bit inefficient if you know it's coming down the line, and I think the spirit of the law would allow you to consider that relief in conjunction with additional relief.
Mm-hmm.
I understand the quandary you're in, and we're all in, but I think there is an efficient way to see our way through it.
What I don't disagree with council about is I do think we'll want the input from the building department, because you wouldn't want, whatever track we end up going down, you don't want to go down twice. So I do think we'll want the input, the official input from the building department, whether there's a further denial letter. And then I'll be following up with the board regarding the process by which they'll choose to proceed. But at the very least, I just think that as it stands right now, I think the local law applies, that the board can't process it.
So what do you,
We would adjourn for all purposes right now until we
until we figure it?
figure out.
Get input from building department.
And if we file an application for a variance requesting a modification of that planting plan, could that join with this application?
That's what I'll be speaking to the board about.
Okay.
And with the chair's permission, what I'll do is I'll leave my cell number with council, and we'll
Sure.
communicate in
Mhm.
between regarding how the board's intending to proceed, or my sense of how the board may be proceeding.
And we agree with you, Jim, your suggestion about a recorded covenant. Yes, that
Yeah, the question is,
that's
Is-
important.
does this even run with the land? Because there's no covenant. And that's another question for council.
I believe it does. Council, that's my name and number.
Okay, so I'll motion to adjourn for all purposes. Case number 3147, 64 Down East Lane, Andrew Fleiss. Can I have a second?
Second.
Second.
And all in favor?
And that's the
Aye.
December 12th?
We will adjourn for all purposes. We can say December 12th, but it's a question for how long it's going to take for Jeffrey to work things out
I
with the
would
building
pro-
department.
I would suggest we have a definite date for now, just
Okay.
because otherwise there would
So-
definitely need to be.
So the motion
a
is
need
to adjourn
reuse.
until December 12th.
Isn't it December 13th?
Oh, I'm sorry, December
I
13th.
don't know what date it is. Is it the 13th?
It's the 13th.
Okay.
Do you know the deadline for getting on that meeting with a new application?
Ooh.
Close?
The deadline for resubmissions would be the Thursday at noon before. If we have to re-advertise, it would be a little bit different.
A little bit before.
Yeah.
Sure. So we should look to get that in, but within a week, I would say, at the latest.
That's a Tuesday meeting, Alex, so like a Friday before?
The Thursday.
Thursday before.
But if they have to put it in
Oh,
the
the Thursday,
newspaper,
so
you
the
have to
8th.
do it,
Yeah.
it's more complicated, isn't
If it had to
We'll
be
have this,
renoticed.
we'll have this application in early next
it?
week.
Okay.
Okay.
Okay, the next case we have is case number 3149, Claire and David Kershey, 37 Pheasant Close North. Is the applicant here to present?
Yes.
Thank you.
Am I able to share my screen?
You have to bring yourself in.
Oh,
Just make sure the audio is off.
yep. Okay. All right. So good evening, members of the board. So what we've done here with this application is we've taken the comments of the board members into consideration, and we have eliminated the plan to do the detached garage. We've done an addition in the rear of the house where we keep the garage as it is. So the only variance we're seeking right now is for the front porch here, which is a 7.62 foot variance off of the front principal building line. And I just want to revisit the tables for the gross floor area and the lot coverage because I know that was originally an issue. If we look down here, we have our lot coverage table. We can see that we are still in conformance even if we eliminate the garage and relocate the addition. So we have the house here at 2338, the little al fresco, which would be off the existing kitchen, which is 215 square feet. The front porch is 147 square feet. The addition is 630 square feet. Tennis court is 5105. And then the pool is 812, which comes out to a grand total of 9,247, which is, below the allowable coverage. To go over the floor areas, this is the existing 1688 with a 2-car garage attached, 593. If we come here, this would be the floor plan with the addition in the rear, which comes out to 2,317. And then no addition to the second floor, so 2,197 existing and proposed for the second floor. And we can see here that is below our allowable, which is 7,500. And we come to a total of 4,514. To address the question of hardship here, we believe that a front porch is a basic element of any residential home. Most homes in this homeowners association in this neighborhood do have a front porch, and we can't physically move the house, and this is really the only location for a front porch to be constructed.
So a few things. We have not had the opportunity to review these plans because I don't believe they were submitted by last Thursday. I didn't have them in my files.
I believe we did submit in time. I don't have records of it, but I believe it's Tajea from your office. We corresponded, and she's behind us.
I could check the file.
Because we emailed a digital copy and submitted a hard copy in person the following day.
Don't you have to submit 7 copies of the hard?
We did. 7 copies of the hard and 1
We have
digital.
it? You have it? I don't have it.
I think you just mentioned that that was submitted the day after, so are you saying that the hard copies were submitted on Friday?
Well, we would have been closed on Friday. We received these on Thursday.
Well, it came in on Thursday. Maybe, no, it was sent to me at 10,000.
We don't have them with sufficient time to review them. I understand and appreciate what you've changed. We just need to.
Is that in what you submitted?
Yes, this is the plan that I've submitted.
Mhm.
In
Um,
color?
Sorry?
This is November 10th.
Yeah, that's what they're showing on the screen. That's what you're looking at.
So the revision date here is November 9th, so yes.
This is
That's-
stamped November 10th.
But what is the revision date? It says 11/9, so that's the same plan that we're showing on our
Yeah.
title block.
Okay, I have it.
Yeah.
So you had it as of Thursday? I didn't get it.
Well, I went in on Thursday because I figured out the building department would be closed on Friday. It is stamped November 10th.
Can you zoom
Of course, I
in
don't
on
know
that
what
site
day it
plan?
is, that's what-
This one?
Yes, please.
Where would you like me to zoom?
The house.
Sure.
All right, that's cool. So we see in the upper left corner of the primary structure where you're proposing to do the bedroom addition. What's the small block just beneath that? The
This
little
right
cube?
here?
Yeah.
This is just a little al fresco. I wasn't sure if it counted towards lot coverage, but I figured I would include it either way.
When you say al fresco, a covered
It's just a
o-
covered.
outdoor area?
Yep.
Okay. And then below that, that rectangle is
That's
just
a patio area.
Okay.
Yep.
So then go to the proposed first floor plan.
Sure.
Okay.
Yeah, it's a
So-
little confusing because
So we're missing like a dotted line above, right?
Yeah.
Okay. All right, that's okay. Did the front porch get larger from your last submittal?
no. So what happened is we had been submitting a plan that showed 17 feet from the accessory. But
Okay.
because that porch is attached to the principal, I believe, Alex, you mentioned that it needs a variance from the principal setback. So that may
Makes
be
sense.
why the numbers were a little different.
Okay.
I need the building department to take a close look at this and confirm that no other variances are being requested other than what was noticed.
Okay, yeah, it looks like the variances that were noticed, most of them were eliminated except for the one on the front porch, which I
Mhm.
believe is reflected on their denial.
It's just.
And we're
the
saying that the
addition-
front porch hasn't changed at all since
It's the
this was
same
first submitted.
footprint, same square footage on every, yep.
If that's all kosher, I think it's fairly reasonable.
Yeah.
But
no,
I would like the
agree.
numbers, so many things have changed. that-
So just to go to the second floor proposed.
Sure.
So we're not exactly seeing your first floor proposed on here, right?
What do you mean?
Because wouldn't we see the roof of the master bedroom?
Right, so that's a matter of drafting and view ranges and whatnot, you
Yeah.
know.
Yeah, got to get the drafting stuff right, though. You know. But I definitely appreciate that you guys have taken the criticisms and the suggestions to heart. That's a good plan.
I think it looks a lot better too, I'd like to say. But there was a sky plane that's been eliminated, so to speak?
Yep, so yeah.
I think the only variance
Is the
request then
porch-
is for the front yard setback.
Yes, so we've gone from 5 variances to 1.
And this house never had a front porch?
Never had a front porch. It was probably a
Well,
design
they saw
flaw.
the setbacks and didn't make a front porch, I get that part.
Could you confirm what the setback is on the plans?
Sure.
The front yard?
So
The
for the
porch.
principal front yard, it's 80 feet, and we're asking for 7.62 feet from the 80-foot setback.
So the setback is 72.38 feet?
Yes.
Okay, that's the way we wrote it on the denial.
Oh, okay, so it hasn't changed?
Right. It's
And
signed,
I
dated
also feel
9/26.
that they've already got the big driveway, which always drives me nuts. So who cares about the, you know?
No, it seems very reasonable.
seems
We
reasonable
we
to me.
appreciate your adjustments. I'll motion to adjourn for all purposes because I want the building department to basically just vet everything you've submitted, look at the GFA numbers,
Parking spots.
but,
Yeah.
you know, we
'Cause
should be able to.
You're adding a bedroom.
We're adding 1 bedroom.
How many parking spots are on there? There's a lot of
So-
gravel
There's,
or pavement, whatever that is.
right.
You can't park in a driveway,
Circle.
though, if cars are going to be going around. You know, you have to.
And
Other
they have
cars
a-
need to be able to
But
leave
don't we
and
have a
all.
garage now?
Yes.
How many bedrooms are in this house now?
I believe it's 1 on the ground floor, 6 total.
Uh-oh. Well, gotta think
So
about that.
they would need, I believe, 5 parking spaces. The garage counts as 2, and you have 2 stacked behind the garage doors would be 4. In terms of calculating the parking.
Is it a one-car garage?
It's a 2-car garage.
Oh, okay, 2-car garage, 2 stacks? So one behind each,
That's
so
right.
that's 4 and you need 3 more?
No, they would need
T-
one
One more.
more to
5.
show on the plans, which I
Is
think.
there any place to put that?
In the,
Well, that car could park in the circular
Right.
Yeah.
element
All
if it's
right.
only 1 car.
So does that solve that problem?
I just recall the building department requiring a site plan with the cars shown, but that's up
I
to
haven't
Alex
seen-
and Tim.
I actually haven't seen that
let
lately.
me just see, I feel
hadn't
like we
seen it
may
before.
have,
With the car, I agreed, it used to be,
Mhm.
and I
Yeah.
don't know what happened.
They've really tortured me on it in the
Oh,
past.
okay,
so.
well, there you go, Lou. You know about it.
I like
Alright,
the
so
I like
wh-
the new design.
thank you.
Yeah, it
So-
seems quite reasonable, like, you know, it's too bad you need a variance, but it's not a big one, so there
Yeah.
you go.
Is there any way to kind of, you know, the client would like to speed up the process a little bit, and I
Mhm.
know I'm asking a lot here, but, you know, if we could maybe, you guys would grant the approval upon the building department's review. They say, okay, the numbers work out, it's all good, it's in conformance, the only thing is the front porch, and then you guys can vote to say, yes, we approve.
We may be able to listen to the building department in the interim between now and the next public hearing, and then we may be able to vote and issue a decision at the next public
Okay.
hearing. So we're leaving it open for all purposes, but we may be able to, to help the client out by doing everything at the next public hearing.
Okay.
We'll try. But for right now, let's, I'll motion to adjourn for all purposes, case number 3149, Claire and David Kershey, 37 Pheasant Close North. Can I have a second?
Second.
And
Second.
Click on the trigger.
all in favor of adjourning for all purposes to December 13th, is that what we said?
Mhm.
To December
Evidently.
13th, case number 3149, please say aye.
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 Aye. Thank you very much.
Thank you.
So we're on to new cases, which is case number 3145, Stephen Skaronek. I apologize if I mispronounced the name. And is the applicant here?
Yes.
Mark, do you need to stay?
Oh, I think you could go home.
We're good, thank you very
You
much.
need Chick?
No, we're good. Thank you, Chick.
Good night, Chick, thank you.
Thanks, Chick. Good night.
Good to see you.
Do you have some smaller sets, if the board members want smaller sets? I will pull them up on the screen as well.
Pulling them up on the screen is preferable.
I'm sorry. Thank you. Good evening, Mr. Chairman, members of the board, and council. My name is Denise Shern. I am an attorney with the Adam Miller Group in Bridgehampton, New York. And I'm here tonight on behalf of the applicants. We do have one of the owners present with us tonight in the audience in case you have questions that are better directed as toward him than me. And we also have our architect with us as well. So if you have questions for him, he's here too. We're here tonight on behalf of an application seeking relief for placing structures within a technical front yard. The property we're talking about is located at 44, do I join as panelist? or-
Yeah.
Okay,
Make sure your audio's off.
I did.
Thank you.
Thanks.
Alright.
Thank you. 44 Hillcrest. This property runs from Hillcrest all the way through to Miller. So it's a double lot. It's in an R 7.5 district. The size is 10,923 square feet. And the proposal is to construct a swimming pool behind the house, 16 by 45, and then a pool house and a garage on the Miller Road Lane, I'm sorry, Lane or Avenue, I can't remember if it's road. I think it's Miller Road, on the Miller Road side. So on the Miller Road side, if you're a passerby or you're driving past and you look at the property, what you'll see is the elevation of the swimming pool, pool house, and the pool house for the swimming pool and the connected garage. The garage will house one car. At the moment, we don't have any area on the property to house vehicles. And the property is unique in the sense that there is nowhere on the property that there exists a backyard. The entire property is either front yard or side yards. Because this runs from one street to another and front yards are created by streets, we have two front yards. So there can never be any accessory structures on the property without some form of zoning relief. So that's why we're here before you today. As the board knows, you must consider whether the benefit to the applicant in having these accessory structures on the property outweighs any possible detriment to the community. And in doing that, you must consider 5 factors. The first factor is whether there's going to be an undesirable change in the character of the neighborhood. We would argue that there isn't going to be a change that would be negative in the neighborhood. In fact, we think that it'll be a positive upgrade to the neighborhood. The house is, you can tell, very well kept. It looks beautiful the way it is, and I have no doubt that with the addition of these structures, the property will be even more attractive than it is today. The second factor that you must consider is whether the benefit can be achieved by some method other than seeking an area variance. In this case, the answer is no. There is no way to install an accessory structure on this property without seeking a variance from this board. The third factor is whether the request is substantial. Considering the answer is either yes or no, you can have an accessory structure or you can't, the relief we're seeking is 100% because we're asking you for a leave valve from that exact specific portion of the law. But I would argue that what we're asking for in terms of relief and the structures that we're adding is not substantial. The pool is smaller than an average pool, or I guess slightly smaller than an average pool, and the combined pool house and garage are, I believe, 520 square feet, but I'll double check that for you. The fourth factor is whether there'll be any environmental negative adverse impacts. My argument for that is that there will not be. We are upgrading to an IA septic system. That is a result of putting the swimming pool in a location where the septic exists right now. So it does have to be relocated, and upon relocation, it will be upgraded to an IA system. I'd also argue that in terms of environmental impacts, the fact that this is 1 unit of density instead of 2 is actually better for the environment than if we had 2 houses and 2 lots versus this through lot with 1 house and standard accessory structures. And the last factor is whether the issue has been self-created. Unfortunately, the answer to that is yes. We did buy the property with that rule on the books. However, I will tell you that when I met with the client today at the property, and he said he came and looked at the property and stood on the back deck and looked at the lawn, which is rather expansive out the back, he thought that he was going to be able to have sort of the pool of his dreams. And after buying the property, he did find out that, in fact, accessory structures would be prohibited as a result of the street on the other side. So I realize I haven't pulled anything up for you to look at. I've just been running through the factors, but I'm happy to pull up any of the plans. I'm happy to have the architect run you through the plans if you'd like to talk to him about the plans, and I'm also happy to just answer any questions.
The one question I have is, there's an existing driveway to be removed. What is that? I'm allowed to go up there.
We can't hear you unless you're.
Should I bring it back to you?
Can you bring the plans up so we can?
Bring them up. Oh, sure. Yes. Have it pulled up, but not on your screen.
Except for share.
this will take longer than.
There you go.
These.
There you go.
Oh, oh, okay.
Put that paper away.
So what you have before you are the elevations of the garage and proposed pool house. The, okay. The, I have to point out in particular the south elevation, because that is the elevation that will face the street.
Well, that's,
I guess they can't see it.
is there a way to,
I'm gonna see if I can pull this up as
Thank you.
a backup.
Oh.
Okay.
there we go.
Thank you.
I sent,
Thank you,
him
Alex.
a chip, he left it.
Oh,
Where's the south? To the left, upper left-hand corner.
Sorry.
Yes.
Yes, that's the elevation that would front the street.
Why is there a garage door on the north side?
That's where the driveway is gonna go in, on that side? On which, on the north side?
On the
of
north.
this- Of this lot line?
So there's garage doors on both sides of the structure, one on the street and then one on the inner yard.
One,
Goes north, oh, I see, why do we have garage doors on both sides? Could you address that? I don't know the answer to that.
Good evening, members of the board. My name is Bill Slight. I'm the architect for the project. The reason that we have doors on two sides is twofold. Of course, from the Mill Road side, it's for the access for an automobile. From the yard side, it's for access for yard equipment, things like that. Also, in the case of if they're entertaining at the pool and they wish to have, use that parking garage space as part of an expanded area within the building for instance, a party, they could have the building open and it would be function like a pavilion.
Understood. Where's the, I see it, pool equipment.
Inside the, you see that?
It's just outside. I mean, it is a pretty big pool square footage wise. I wouldn't call it a smaller than usual pool.
Oh, I thought, well, 20 by 40 I thought was typical, and then 15 by 30
This is 15 by 45.
45,
Yeah.
it's huge.
Yeah, we're still
It's
over,
not-
we're over
it's
700
narrow.
square feet.
And the combination of lot coverage for the pool house and the proposed garage is almost the equivalent of the size of the house.
The
Well,
house is
So that
very,
is not-
A typical pool is 20 by 40, so
We're not
that's 800
discussing
square
a
feet.
typical pool, we're discussing this pool.
No, excuse me. A typical pool is 20 by 40, which is 800 square feet. What we're proposing here is 846 square feet. So it's not a significant difference between what you're accustomed to seeing on many properties. It's simply configured in a different way.
Correct, I agree.
and we've, the directive from the client was to make sure that we stayed within all, dimensional regulations, so. It's under on coverage, it meets all the setbacks. It is literally just the fact that we have a lot that runs from one street to another street. That's the reason we're here for the variance.
Julia, do you have any questions or comments? Julia?
I'm thinking, no, not at this time, Mark.
If I might, I might point out one other thing about the length of the pool,
Although it's hard for me to remember when we've provided the opportunity for a front yard variance for a pool in the time that I've served on the zoning board. I can't recall it.
Yeah, for me, I don't necessarily have a problem with the size of the pool. I just want to point out that it's not really smaller than normal pools. It's very much in keeping with a typical pool size.
The length of the pool, if that's an issue, the owner wishes to have a pool in which they can swim laps.
Sure.
And so, you know, when they first came to me, they wanted a pool that was 50 feet long.
Right, right.
You know, we've tried to, you know, get this in a size that all the elements on the lot will work. The ability to have, you know, some lounging space around the pool, separation of the pool from the existing house, the distance as much as we could get it from Miller Road. As far as Julia's comment about it not having come up, there are only actually about 2 or maybe 3 roads in the entire village which compel this condition.
Right.
One of which is over on Murray, houses on Murray Lane, end up fronting on, I can't remember the name of it, Brandywine. I think it was Brandywine or something like that. The road that's just to the east of that. And this road, and there's one other place, but I can't recall where that is.
We've seen 2 in the past
Mary Lee
year. One was the
Drive.
one on Ox Pasture.
Ox Pasture and Mary Lee.
Yeah, exactly.
We had a recent
Say that again?
application, Mary Lee Drive and Ox Pasture Road.
Thank you.
Hmm. And then there was one over by where Schmidt's was, right? Or am I thinking of it correctly?
Yeah, and
Right,
it was
like a
Eel
paper road.
Pot.
Yeah,
You know,
yeah.
and, you know, we did
Oh,
have
Eel
that.
Pot Lane, my favorite,
Yeah, actually, we did grant that one,
Yes.
Julia.
but that wasn't really a road.
Yeah, no, I agree, but it was at the end.
Okay, this to me
I'm-
seems like a big ask to me, I don't know.
What's
Well,
your,
I think that for me, and I appreciate that you started right with the 5 points because sometimes it gets a little cloudy. But when you start to talk about impact on the neighborhood, and maybe this starts to get more into the homeowner's perspective, this would represent the first step in the gentrification of this neighborhood and could potentially, down the line, displace people. And this could start the domino, this could be the first domino of a rise in property values that really pushes people out.
Well, I don't know if it would be the first step, because I went there today, so I can see there's lots of houses that are under construction, and a few that I can see on the aerial have pools behind them, so.
How many pools are in
Yeah, how many
this
pools
particular
really?
situation, Hillcrest and Miller?
Hillcrest and Miller, I don't know. It's the house across the street, across from Hillcrest. So the house across the street to the right. So it's one house over, and behind that there's a swimming pool that you can see that's going in. I'm
But
sorry.
that isn't
Alex, do you have an
between two
aerial
streets,
of
right?
this
No, I
area?
think we were just talking about the gentrification of
wasn't.
the area.
Okay.
Okay.
I'm asking specifically
don't-
between these two streets, do you see any swimming pools? I mean, I'm gonna go over there, but I don't like to walk around in people's
Yeah,
backyard.
no, I understand. No. I didn't see,
I
there
don't
was
feel
none that I could,
comfortable. How's that?
none that I could visualize from the
But
street.
the aerial, maybe Alex can
Alex
pull
is
it.
calling up
He's
the
working
aerial.
it.
It starts to represent a level of development to the property that may not be in keeping with the neighborhood.
That's not it. I think
I
it's
don't
just a lot of things. I think the house is a modest size, and then we have a big pool, and then we have 2 other things that are conjoined, like the pool house and the garage. I don't feel particularly comfortable with the description of having the 2 doors, because I feel it makes it the garage could be a potential living space, which I don't feel comfortable with. We had this on.
And Alex,
Walnut?
isn't there, I could be thinking of another jurisdiction, but isn't there a relationship or a ratio between how large an accessory structure can be relative to the primary structure? Am I imagining
I think
that?
there's just a cap on
Okay.
accessory structure size.
Okay.
So, I don't think we have that, but I hear what you're saying.
They're both almost the same size.
Well, and also, they're pretty big. I mean, the house isn't big. That's the starting point, right?
Right.
So now we're being asked for 3 different accessory structures, correct?
Correct.
And
No,
so-
2 different accessory
No,
structures.
the garage and the pool house?
Well,
The
it's one
garage and the
structure.
pool house is one
And-
building, and the pool is a
Well,
another structure.
They're, okay, that's even more disconcerting to me, and the pool. So I don't know.
Alex, what do we see in swimming pools? I see one there on,
Yeah, you're looking
Wow.
at, this is Hillcrest
Can we
Avenue.
swing in there a little closer?
You'll notice that not all of the lots are through lots, so it's not
I
going
wanna
to be
see yeah,
a perfect comparison, but this is that block.
Yeah, can we zoom in? Thank you.
so they're no swim. Do you see any swimming pools? One. Is that the through lot?
It's, I would have to check ownership records. It's 2 lots, but they
Oh, it
may,
is, one's vacant?
but one, yeah, they may be owned in common.
Is there a house there?
With
Is
the
it that
swimming pool?
little,
Yeah.
Yes, there is.
Where's that?
at the end of the driveway?
Oh, I'm sorry, there's a little bit of a delay if you're looking at the pool there. I believe that's 108.
I'm lost. Where'd that pool go? Oh, there you go. Is there a house there?
Yes,
I think it's at the end of that driveway.
lower
To the
right
far-
corner.
yeah, that's
This little thing there?
Yes.
Okay. An inhabited house? I mean, really? The house is smaller than, close to being the size of the pool, no?
Oh, on that property?
Mhm.
I would estimate, yeah, it looks about the same.
That just, I don't get that. I'm going over there with binoculars. Is that the only one? Because the other people don't really have room for a pool? Yeah.
on this particular
may have
block.
room.
96 I don't know if you'll be able to find
Yeah,
96 Miller.
There's a pool. I see one.
Yeah.
Yep, this is 96 Miller.
Oh, it is,
On the-
okay.
on the
Double
south
lot?
side.
That's a double lot?
It's a,
Kind of.
it looks like a corner lot. Oh, no,
Yeah.
sorry, it's not. It's an interior lot.
So that's different.
I think there's a road there that
a-
separates them.
There's a flag lot behind it.
Oh, I see, okay.
All right, thank you.
So the question we're wrestling with is whether it produces a detrimental change to the neighborhood. But let us look over some aerials, visit the property, and I do want to make sure that we've looked for any subdivision maps, because this is an unusual situation, but it was created this way. So I am wondering if some of the original subdivision maps, if we can locate them, address, the idea that you have properties that were created and have frontage on 2 public streets.
If it's as old as I think it is, it may
It
predate
is.
the zoning ordinance.
It's from 1927, the
Oh,
map.
dear.
Properties of that divided at that time are modern subdivisions, as we know them now, that go to the planning board and have zoning modifications. I don't know if there was zoning in effect at the time, but it likely wouldn't have been reviewed by the village.
It would have
in the
just
same
been
way as a
lines
modern-
drawn on a map and filed at the county.
Helpful for
Chair, I
me.
do have a hand up on Zoom.
Yeah,
A step- okay.
we'll get there in a moment, as soon as, okay, so your presentation is wonderful. We may have more questions as we
Thank you, Chairman.
discuss amongst us.
I just know the owner would like to make one comment, if that's okay.
Of course.
Hello. So, I'm Steven Skowronek, one of the owners of the property, and we bought this property a little less than a year ago, December of last year. And I guess I'm confused because I didn't realize that when you buy a property in certain areas, you're allowed to have pools and auxiliary structures, but not in others, because of the makeup of the community.
No, it's,
No, it has to do
with
with being in a
zoning.
front yard.
you can't have a pool in the front yard and you can't have accessory structures in the front yard. So you're in a peculiar situation, you have 2 front yards, and that's why you're before us.
Okay, well, you know,
Nobody told you, right, okay.
yeah.
But that's what lawyers are for.
Yeah. Yeah, so, I mean, I guess I just feel a little, you know, we bought this property, we saw this amazing backyard, what looked like a backyard to us, and we thought, oh my gosh, we're gonna be able to get our dream pool here, and we, you know, we didn't realize that it would be such an issue to do this, and this very, very, very long yard, which is,
Right.
you know,
Yeah,
incredibly
and
long.
it would not be an issue if Miller Road was not there. If it wasn't
Between two.
basically adjacent, your backyard is adjacent to a public road. So
Mhm.
it's referred to as 2 front yards, but let us,
And if
you
we're
know.
putting a structure on Miller to make it appear like the other houses on Miller, that doesn't,
no, I recognize that, it's thoughtful. It is thoughtful.
But it still counts as an accessory structure through zoning, right?
okay.
Right.
Because
And we would
you
hope
have the
for a
main
garage
house.
door to not be on the street. You know, nobody really likes garage doors on streetscapes now.
So is it possible to just put a pool in?
Well, that's a consideration.
Yeah.
We have to talk.
It would also need a variance.
Yeah.
The variance that you've requested as part of this application.
But it would, you
It
know,
would-
removing the garage and the party barn does become less development on the property and less of a burden, to me at least, on the neighborhood, and would be more harmonious.
And the pool is a considerable distance from Miller Road. So yeah, thank you
a
for
good
mentioning
idea.
that.
Okay, thank you.
I'd like to point out something for the client. This, you know, one of the reasons that he wishes to have a garage is that, you know, like many people who own second homes in the Hamptons, you know, there's a wish during certain seasons to have a car stored there
Right.
under cover, rather than leaving it in the front yard, which it currently is on Hillcrest. So this would, you know, remove the population of the area by visual population of the area by additional vehicles. So, you know, that's one of the considerations. If the issue of the door facing the road is significant to you, it might be possible for us to turn the drive so that it comes in on the side. I can, you know, reconfigure the way the building happens. The comment that there aren't other, that it's, you discourage the front-facing garage doors. If you drive around that neighborhood, you know, the other
They're
adjacent
all
streets,
over.
there are a number of
Sure.
homes there. I would call them a typical American ranch house style homes, which have front-facing garages as part of the structure of the house.
Agreed.
So it's not something that would be aberrant to that area.
Right. Right. I have no doubt, Bill, you'll be able to design something that fits and is beautiful. I think what will be helpful also is to solicit many more letters in support of this from the neighbors. All we have so far is someone who makes valid points in opposition.
Oh, okay, I haven't seen that yet.
It's in the file, yeah.
Okay, so let's move to listening to any members of the public who may wish to be heard, and thank you.
Wasn't there one?
Takes a minute.
Oh, okay, sorry, Charles.
I'm here. Good evening, thank you for your time.
Thank you for taking the time to be here.
I appreciate all your expertise. So,
Could you state your name, sir?
Oh, I'm Stephen Mara,
And your address?
I'm one of the, yeah. And so I just also wanted to say that we also,
Sir, we just need your address, please.
oh, I'm the other owner of Hillcrest.
44 Hillcrest is your address?
I'm the other owner of the Hillcrest property. And
Okay.
I couldn't
We
be
need it
there,
on the
so I'm
record, that's all.
filling in.
Go ahead, Stephen.
Thanks again for your time. So I really think that we really respect the parameters, and we're trying to create the structure there to act more like a building barrier, so it would appear from Miller Road more like a home that also had a backyard, and so it wouldn't feel like incongruous, you know what I mean? The idea that, like, we actually don't need that size building. It was just a matter of creating something that would look more, because we could absolutely just put a shed for our garden equipment and all that stuff. It would absolutely save us a lot of money to do so. And so if you think that we could just put a shed and a simple garage, then, but the idea of it was to try to create the barrier for the property. And I also want to make sure that it's noted that we are upgrading the septic system for the property to the contemporary septic system. I really, as somebody who really worries about the environment and the impact that we make, I do worry that, you know, they're trying to upregulate the amount of volume that's going right behind Hillcrest. Right, they're trying to make that housing, and there's no sewage system, right? So this is actually a way that we're actually improving the property, because it's going to have, it's going to have a structure on there that's going to look more finished rather than just having an open backyard to a road. And B, we're upgrading the septic system, which I think is important. So I just wanted to make sure that was recognized.
So, thank you, Stephen. Do you think it would be helpful if Bill created a plan where it was a garage only and eliminated the pool house?
I'm not willing to say.
Okay, so let's hold off on that. Okay,
Sorry.
fine. For right now, let us
Watch
talk.
out.
It-
Sorry,
But you're,
I can't see who's
It's
not
okay.
willing to say.
No,
the
we're
the
done.
point's well taken, that the pool is the primary objective. That's the primary
Yeah.
benefit that you're trying to
Yeah.
achieve.
And we actually only did this because we thought that it was going to be, you know, more palatable, that it wasn't, you know, the truth of the matter is it's a small house on not a big property, and all of the equipment and all of that stuff could get to an empty lot from an open road. So it felt like it was actually being less imposing to the neighbors. Yeah.
No, I appreciate that.
And there's actually 4 pools. So there's a new pool at 20 Hillcrest. There's a pool directly across the street from us. And that pool that's directly across the street from us on Hillcrest is in their side yard. It's directly, yeah, it's not in a backyard.
But it's not in the front yard either.
Yes, it is.
So the front yard is, because the house is very close to the street, actually not even within, like, remember too, that when we did the auxiliary building, it's with the full setback of an auxiliary building. It's not like it's, we're asking for any variance in terms of its proximity. But we really would like to, if you, I think you just want to think about what the ask is here. It's not really that we're trying to, it's interesting because this is my second meeting, and the last meeting was about the town of Southampton trying to increase the amount of housing available. And so it's amazing that we are now just trying to ask, and we're not asking for a living structure. We just want to be able to close off the space from the road.
But this is the village, not the town. Many people in the village would agree with your estimation of what's going on vis-a-vis the town nearby, just saying.
Yeah, I would love for the septic thing to be better thought out. It's part of the reason that it just seems odd to be on a sandbar with all of these, septic systems, but.
Well, all new projects are required by the county to have these new systems, so it's not really anything new. I guess my question
Right,
is,
but if we don't do the project, it wouldn't change. It would be the old septic.
right, so there's these two.
Is my point.
That's your point. I understand.
Yeah.
So there's.
So if you deny us from doing it, it'll stay the old system.
Sure. I get your point now.
And the old look, which is that from the neighbor's front yard, they can see us hanging out in our backyard.
So the new sanitary system is going to service the existing main house?
Yes. Because it's not a big house.
Right, I'm just talking about the.
I'm not even sure if it's 1,000. It's, it's not a big house.
In my experience, and maybe Bill can speak to this, you're actually not showing the sanitary line from the main house, past the pool, underneath the pool house, and then to the system as it's proposed on Miller Road. It really just looks like we're proposing a seasonal system that will service the pool house. That's a really long run.
It's a long run, however, the property slopes. So we're taking advantage of the natural pitch of the land. And what we've done is, where the existing septic line exits the house is on that easterly side of the house. We've kept the waistline and run it into the foundation of the proposed new structure.
Okay.
And by that, we are permitted to make the turn, the 45 or 90, in a sense, actually a 90-degree turn, in order to have access to the position on the property where it would be best to position the new IA system. The existing septic system was placed in the very middle of the property. I mean, literally in the exact middle of the property, foreclosing a lot of future use of the property.
Right.
So that's one of the reasons why it's also being repositioned. But you're absolutely right. If this was a totally level plane, it might be a problem. we don't have that problem. We have gravity
Okay.
in order to get to the system.
Do you have an RO number for this yet? Has it gone
Yes,
to the?
it's been
yeah,
approved.
This has been approved.
Yes.
Okay.
All right?
I would like to make a comment. Mr. Mara, actually, I think the question is not what we would approve, but what do you truly want? Because through the course of the presentation, there's clearly some flexibility in terms of what you're asking for. And our obligation as members of the zoning board is to consider the very least that is necessary. And I will also say that while it may not seem significant, the request for a pool and an accessory building in a front yard is highly unusual, and one that we always deliberate very thoughtfully and take a great deal of consideration, because you knew, as your attorney represented, that it was an unusual lot when you purchased it. But the best thing for you and your advisors to do is to bring us what you actually feel you must have. Because we're not in the negotiating game, really. It's gonna be a yes or a no, and we need to know specifically what you want. Because we're not in the let's make a deal business.
No. Well, I thank you for hearing me. So, yes, I'm not asking you to negotiate. I'm trying to, if you think that it's reasonable for us to just put the pool there without the garage or the pool house, then we're done.
It is less of an ask.
Okay? I mean, so
Yeah.
remember that this is,
I'm not meaning to say what.
that's fine. So just the pool.
If that's really what you're asking for, then that would be what I would be presenting.
You don't have to answer now. You guys can
Yeah.
talk amongst yourselves as we will.
right?
But it does seem like the variance request can be reduced, is what we're hearing.
Okay.
For right now, we're going to motion just to adjourn for all purposes, and then we'll take another look at perhaps a revised plan on what you decide you really need that might be less substantial. And can I have I'll motion to adjourn for all purposes.
That was the last of the public, right, Charles?
I thought we did that.
Okay, I just wanted to make sure that.
Yeah,
we were-
no, let's double check.
Go ahead.
Okay, thank you.
Okay. So we'll adjourn for all purposes, the application regarding 44 Hillcrest Lane. Can I have a second?
Second.
And that's to the December 13th meeting?
And we're going to adjourn it to the December 13th meeting. All in favor?
Aye.
Aye. We are noticing that the application with respect to case number 3142-161 Cargan LLC has been withdrawn by the applicant. And then I will motion to close the public hearing. Can I have a second?
Second.
Wait,
Mhm.
Mark, did they mean to withdraw or just not to reopen based on the agenda request? Are they still looking for a decision from us, or are they out?
No.
The way they worded their letter to me, and it's in the file, was to withdraw.
Okay.
If you withdraw, you're gone.
Agreed.
It's withdrawn. We don't have anything with respect to 161 Corrigan before us. So motion to close the public hearing, Tuesday, November 15th. Can I have a second?
Now, I have a,
Oh, I'm sorry. Who is it?
Christopher Lawrence.
Oh, no. We're closing.
Oh, I mean, we can let him know. How can we let him know that we're closed on that?
I'm sure he can hear you.
Okay, Mr. Lawrence, we're closed, but we have not rendered a decision yet. We're still discussing the decision amongst ourselves.
Oh, on.
That's Great Plains.
Okay, yeah.
And Mr. Chairman, before we leave today, we just need to discuss at least the January schedule for the board.
Okay.
Because we've passed the deadline now for December submission, so new applications we take in are going to get scheduled for next year. So we just,
Is there some controversy about it?
no, I just want to make sure that we're in agreement that we have some meetings scheduled in January.
Okay. Is the meeting closed yet? We didn't vote, did we?
So we could stay open just to clarify the January
okay.
schedule. on-
Okay, do we have dates on the website, Alex?
No.
Not yet, Charles.
I don't think that the 2023 calendar has been put up on the website yet, but I'll look at the calendar. If we follow the same format that we have been, I can tell you when they would be, which would be Tuesday, January 10th, and Thursday, January 26th.
There's some, are those holidays any of those?
No, Martin Luther King Day is Monday the 16th.
Okay, that's good. And there's
Then-
President's Day, or is that
I
February?
think that would be
February.
I always
February.
get those mixed up.
That's fine with me. Tuesday,
Alright with
January
me.
10th, Thursday, January 26th.
That's-
Can't wait
Okay.
for January.
It's hard to believe we're already talking about January, but yes.
I don't think it's that far off.
So a motion to close the public hearing, and can I have a second?
Second?
And all in favor?
Aye.
Aye.
Oh.